Hello, everyone. My name is Susan Farbstein, and I'm an assistant clinical professor here at the law school and one of the directors of the International Human Rights Clinic, which is part of our human rights program. And on behalf of the Human Rights Program and our co-sponsors today, which are the Harvard Law Students Advocates for Human Rights, the Harvard Human Rights Journal, the Harvard South Asian Law Students Association, and the Ahmadiyya Muslim Lawyers Association of the US, I wanted to welcome everyone to the law school today. Mr. Rahman, as you know, is a senior advocate of the Supreme Court of Pakistan. He has quite an extraordinary legal career that spans 53 years of practice. He's led the fight to protect the human rights of the Ahmadis in Pakistan and argued some of the seminal cases. I'm also happy to welcome back to the law school my friend from our days as students here, Amjad Khan. Amjad has been working on these issues since we were students, since we were law students. He's now litigation counsel at Aiken Gump, as well as an adjunct professor at UCLA School of Law, and he spends hundreds of pro bono hours working on these issues. So I'm really grateful to Amjad for reaching out to us and bringing this event to the law school. I just wanted to say a word about the logistics. As you can see, the event is being recorded. Amjad's going to do a longer introduction and give us some context, and then Mr. Rahman is going to speak for about 35 minutes. At that point, when he finishes his talk, I would ask that those who need to go to get to their 1 o'clock classes go then, so we don't sort of have a slow trickle. And after those who have needed to leave have left, then we can take some questions from the audience. So with that, I'll turn it over to Amjad.
Thank you very much, Susan, for that kind introduction. I'm truly honored and privileged to introduce to you our keynote speaker, Mr. Mujeeb-ur-Rahman. But to help put Mr. Rahman's remarkable background and contributions in their proper context, let me first provide a brief overview of who the Ahmadis are and the scope of the persecution they endure. Founded in 1889, the Ahmadiyya Muslim community is a revivalist movement within Islam. Ahmadi Muslims believe in the kalima, which is the principal creed of a Muslim, and they self-identify and profess to be Muslims. The fundamental ideological difference between the mainstream Sunni Muslim majority and the Ahmadiyya Muslim community concerns the identity of the Mahdi, which is a reformer, and Masih, the Messiah, in Islam. And Ahmadi Muslims believe that their founder, Mirza Ghulam Ahmad, occupied both of those roles. The Ahmadiyya Muslim community is among the most persecuted Muslim communities in the world. The US State Department, the US Commission on International Religious Freedom, and dozens of human rights NGOs, Amnesty International, Human Rights Watch, have documented the systematic persecution endured by Ahmadi Muslims at the hands of religious extremists and state and quasi-state institutions in numerous countries around the world. That includes Pakistan, India, Bangladesh, Kazakhstan, Kyrgyzstan, Indonesia, Saudi Arabia, Egypt, Libya, and Syria. Today, Mr. Rahman's talk will focus on Pakistan, which has become a particularly disturbing case study in religious intolerance as it pertains to the Ahmadi Muslims. While the precise counts are difficult to establish, some researchers and scholars estimate that several million Ahmadi Muslims live in Pakistan. As I mentioned, Ahmadi Muslims self-identify and profess to be Muslims, but their belief is irrelevant under the law. And that is because Pakistan is the only Islamic state in the world to define explicitly who is or is not a Muslim in its constitution. This is Article 260. And the Second Amendment to Pakistan's constitution, which was enacted exactly 40 years ago in 1974, it amends that definition to explicitly state that Ahmadi Muslims are not Muslims, denying their right to self-identify as Muslims. And as has been well chronicled by the international community since 1984, Pakistan has used its criminal code to prohibit and punish blasphemy. Now, blasphemy, as a legal term in Pakistan, broadly refers to any spoken or written representation that, quote, directly or indirectly outrages the religious sentiments of Muslims. And 5 of Pakistan's current penal code provisions punish blasphemy. These are what are collectively referred to as the anti-blasphemy laws of Pakistan. The most notorious of these is a 50-word penal code ordinance, section 295C, and it reads, whoever by words, either spoken or written, or by visible representation, or by any imputation, innuendo, or insinuation directly or indirectly, defiles the sacred name of the Holy Prophet Muhammad, peace be upon him, shall be punished with death or imprisonment for life, and shall also be liable for a fine. And based on this remarkably broad language, virtually anyone can register a blasphemy case against anyone else in Pakistan, and the accused can face capital punishment. Now, for Ahmadi Muslims, Pakistan's anti-blasphemy laws have essentially criminalized their very existence, because 2 of these 5 laws, which are known as Martial Law Ordinance 20, I'll refer to as Ordinance 20, and I'm sure Mr. Rahman will as well, these amended Pakistan's Penal Code and Press Publication Ordinances, Section 298 B and C, and state that for fear of, so Ahmadis, for fear of being charged with, quote, indirectly or directly posing as a Muslim, Ahmadis cannot profess their faith either verbally or in writing. So what has happened has Pakistani police have destroyed Ahmadi translations of the Quran. They've banned Ahmadi publications. They've banned the use of any Islamic terminology on Ahmadi Muslim wedding invitation cards, the offering of Ahmadi Muslim funeral prayers, the displaying of the kalima on Ahmadi Muslim gravestones. And in addition, Ordinance 20 prohibits Ahmadi Muslims from declaring their faith publicly, propagating their faith, building mosques, or making the call for Muslim prayers. So in short, virtually any public act of worship, devotion, or propagation by an Ahmadi Muslim can be treated as a criminal offense punishable by fine, imprisonment, or death. And so not surprisingly, having suffered under these laws for years, religious minorities have challenged the constitutionality, the legality of the anti-blasphemy laws, particularly under Article 20 of Pakistan's constitution, the Fundamental Religious Freedom Clause. And these laws have been upheld and have withstood legal scrutiny. There are 2 cases, and I won't go into a lot of the details because our speaker has argued them, and we'll talk about them. The Ordinance 20 that was enacted in 1984 was challenged in federal Shariat court in Pakistan. There are 2 tracks of court systems, so the highest religious court in Pakistan. And they were asked to rule on the question, is Ordinance 20 contrary to Islamic principles? Not the Constitution, but Islamic and Quranic principles. That case was Mujeeb-ur-Rahman versus Government of Pakistan, 1984. And Mr. Rahman was both the lead petitioner and the lead counsel on that case. And what the court did is they upheld the validity of Ordinance 20 and ruled that the parliament had acted within its authority to declare Ahmadi Muslims as non-Muslims. So Ordinance 20 merely prohibited Ahmadi Muslims from, quote, calling themselves what they're not, which are Muslims. So in 1993, the Supreme Court of Pakistan dismissed 8 appeals that were brought by Ahmadi Muslims. These were consolidated in a case that challenged the same law under the Constitution. And the court upheld the validity of those laws on 2 grounds. First, the court held that Ahmadi Muslim religious practice, however peaceful, angered and offended the Sunni majority in Pakistan, and to maintain law and order, Pakistan would therefore need to control Ahmadi Muslim practice, and so Ordinance 20 could do that, control. The second holding was that Ahmadis, having been deemed to be non-Muslim by that amendment 40 years ago, they could not use Islamic epithets without violating company and trademark laws. Pakistan, the court reasoned, had the right to protect the sanctity of religious terms under trademark laws and company laws so that they can't be wrongly used by non-Muslims. And the court also pointed to the sacredness of religious terms as well. So this opinion further entrenched these ordinances. So in light of these twin decisions, the laws remain a state-approved instrument for persecution of religious minorities, and particularly Ahmadis. Now, I've had occasion to testify before the U.S. House of Representatives recently, just a few months ago, and also in the past several years, about the ill effects of these laws, the grave human rights violations that emanate from these laws. And recently, I summarized the predicament of Ahmadis as follows. First, many hundreds of Ahmadis have been murdered in Pakistan since it was founded. The past 4 years has been especially brutal, with targeted killings of women and multiple members of families, of the same families, and the targeting of Ahmadi Muslim doctors, lawyers, religious leaders, businessmen, and teachers. And this includes several American citizens who were killed, including a doctor very recently. And in 2010, 86 Ahmadis were gunned down by the Pakistani Taliban on May 28th in one of the largest terrorist attacks in Pakistan's history in Lahore. Since 1984, as I mentioned, every single Ahmadi Muslim woman and child in Pakistan is declared to be non-Muslim by constitutional amendment. Since 1985, millions of Ahmadis cannot, by operation of law, fully and freely vote in the national and provincial elections. And as of 2002, Ahmadis are the only religious group in Pakistan that are not part of the nation's joint electorate. They can only vote if they, one, declare themselves to be non-Muslim, they declare the founder of their community to be an imposter, and add their names to a supplemental list. And to date, 4,000 cases, about just under 4,000 cases, have been registered against Ahmadis under the blasphemy laws, and now Ahmadis account for almost 40% of all arrests under these laws in Pakistan. And finally, to date, Pakistan authorities have demolished, set on fire, forcibly occupied, sealed, or barred the construction of over 90 Ahmadi mosques under these laws. They have also denied the cemetery burial of at least 41 Ahmadis and have exhumed, after burial, the bodies of 28 Ahmadis as well. I see several patterns that emerge from this. The police at the provincial and local levels routinely fail to provide adequate protection and safeguards for vulnerable Ahmadi Muslims, despite receiving adequate notification of imminent harm and threats. In some extreme cases, police are complicit in this persecution. They torture and contribute to the murder of Ahmadi Muslims. Ahmadi Muslim professionals, physicians, lawyers, and teachers are targeted specifically. The perpetrators of deadly attacks on Ahmadi Muslims are rarely arrested and charged for these criminal acts. In some cases, these perpetrators are permitted to act with impunity and even given legal sanctuary and safe havens. And many frivolous blasphemy cases are routinely registered against Ahmadis. So with that background and context, let me now introduce our keynote speaker, Mr. Mujeeb-ur-Rahman. Mr. Rahman is among Pakistan's most renowned lawyers and is a noted Islamic scholar and author. As was mentioned, he's a senior advocate of the Pakistan Supreme Court and founder of his own law firm in Rawalpindi. He graduated from the University of Punjab in 1957 and obtained his LLB from the University of Karachi in 1961. For over 53 years, Mr. Rahman has argued hundreds of cases, including scores of cases before the Pakistan Supreme Court. He has devoted the lion's share of his legal career to the cause of religious freedom, and some refer to him as the Thurgood Marshall of Pakistan. He has defended hundreds of cases registered against Ahmadi Muslims under these laws. Most notably, I mentioned Mujeeb-ur-Rahman, where he was the lead petitioner and counsel in the Shariat court, and Zahiruddin versus the state, that Supreme Court decision. He challenged the prosecution on the grounds that it violated the rights of religious freedom under Pakistan's constitution, that the law was discriminatory, vague, and overbroad. In the judicial history of Pakistan, Zahiruddin is a landmark judgment. And its effect on the role of religion in Pakistan's state and society is perhaps best analogized to Plessy versus Ferguson here in the United States and its impact on the relationship between race and law in the United States. But not only is Mr. Rahman's human rights advocacy unparalleled in Pakistan's recent history, his legal acumen in other areas, including military and criminal law, is highly prized. In recent years, actually, he served as the lead prosecutor in a case against the accused perpetrator of a 2003 suicide bombing aimed at General Pervez Musharraf, who was the chief executive of Pakistan at the time. There was an attempted assassination. He served as the lead prosecutor, and he was asked to serve as the prosecutor by the government of Pakistan. Indeed, Mr. Rahman's areas of expertise span all areas of Pakistan's constitutional, civil, criminal, and military law, as well as Islamic law and jurisprudence. Without further ado now, with that long introduction, let me now give the balance of this lecture and time to Mr. Rahman.
Please note that he has only given me the balance of the time. Ladies and gentlemen, the academia, the students of the Harvard Law School, it is indeed a great pleasure and a great privilege to be here. I have never been in any one of the universities here in the Western countries, addressing so many students and a galaxy of academia and the students having law as their career. I had a passion for law, and I have served the law as best as I could in the last 3 years of my life. Amjad has said very fine words for me. It is customary to say, don't believe a word of what he said. I will not say that, but I will certainly say that sometimes many good lawyers also overstate their case. So be on your guard. He may have overstated his case. And thereafter, before I start, ladies and gentlemen, I see people from various nationalities maybe, and Americans, and maybe many Pakistanis. So I take this opportunity to start with saying, Bismillahir-Rahmanir-Rahim, Assalamu alaikum. Why did I say that? I did not have to say that. That is not how we greet each other here. I have been greeting everybody here, good morning, good morning, good morning. Why did I say Assalamu alaikum? To register here in this Harvard Law College that if I said that in Pakistan, I could be sent to jail for 3 years. I have not been sent to jail. Somehow, my legal profession has protected me, but my fellow co-religionists have gone to jail for saying Assalamu alaikum, which is the customary way of greeting citizens in Pakistan. Even Christians would greet each other as Assalamu alaikum. It's almost reflex action, and people have gone to jail for that. So that is the background. And Amjad has given you many details. I would not go into that detail. The organizers of this lecture have given me a specific subject. I will talk on that subject. As for me, I am reminded of a Persian couplet which says, Tan hama daag daag shud, pamba kuja kuja neham. My whole body is bruised with wounds. Where shall I put the balm? So if I were to show you my wounds which I have suffered, some of them which he has mentioned, I would perhaps take the whole time. I would not do that. I am not here to win sympathy of my audience. I am here to discuss a purely academic subject from a purely academic angle. And I am going to talk of the constitutional issues here in America because my constitution, I carry the Holy Quran with me for my daily recitation, and I carry this pocketbook constitution with me all the time because my faith is dear to me, and whatever my constitution may have done to me, I still follow this constitution, I still honor this constitution, I still protect this constitution, and it is that constitutional issue that I am going to discuss with you this morning. Now, before I go there, and before I take you to Southeast Asia or South Asia, and I see some scholars here, Asad Ahmed is sitting here, and some others who have worked in South Asia, and they are sociologists and anthropologists, and they have done great work of research. I will not comment on their work here, but I can see all these gentlemen here. But before I enter that, let me tell you that the crest of the Harvard has really inspired me. it has captured my attention. And let me say, the crest of the Harvard Law School has captured my attention. Quest for truth, discovery of truth, preserving truth, upholding truth, spreading the light of truth, dispelling the darkness of ignorance and untruth are the highest ideals that man can think of. So I congratulate you, and inspired by that, I am here to share with you some truths. Some truths which I bring from my own country, which you may not be familiar with. Some truths I will mention from your own country, from your own constitution. This constitution of Pakistan has borrowed a lot from the American Constitution. Our jurisprudence in the Pakistan Supreme Court over the last 50 years has cited hundreds of cases from the American jurisprudence, and mostly rightly cited, rightly followed, rightly analyzed. But in Zahiruddin case, a dozen of American cases were wrongly cited, wrongly relied upon, and wrongly interpreted. Way back in 1994, a group of Minnesota lawyers prepared an amicus brief to be presented in the Pakistan Supreme Court. I received that brief. I was the counsel. It could not be presented because of the procedural regulation of the Pakistan Supreme Court. There was no such procedure, and the Americans' lawyer did not have a right of audience. But those lawyers, and I understand Amjad has also worked on that, to explain how the American case law was misapplied to give the color of fairness to Zahiruddin case. And I pause here to say that some of our studies, some of the studies carried out here in Harvard Law or Harvard University have, in a strange way, tried to justify Zahiruddin on reasons other than legal grounds. I will not mention all those, but when I will refer to some of the comments which were passed after the Zahiruddin case, but let me start with sharing some truths which I wish to recall and which I wish to rely on. First of all, let me take you to a famous saying of a lawyer here in America defending a blasphemy case. Colonel Ingersoll had said, "I deny the right of any number of men, of any church, of any state, to put a padlock on the lips, to make the tongue a convict. I passionately deny the right of heralds of authority to kill the children of brain." Now that is a fellow lawyer from America who spoke that truth, and he spoke another truth. And he said, there is a constitution higher than any statute. There is a law higher than any constitution. It is the law of human conscience. And any man who is a man will not pollute or deny his conscience, pollute his conscience at the bidding of a legislature. So I am here to tell you and share with you the truth that the Ahmadiyya community, with everything done to them, have not denied or polluted their conscience on the bidding of Pakistan Constitution. We will not pollute our conscience. We will continue to keep our faith. And I, as a man, so long as I live, I will try my best to have the Zahiruddin case overturned. Why I say that? That hope also came to me from United States. In the United States, way back in 1930s, you remember there were Jehovah's Witnesses cases. And in those cases, at one point, American Supreme Court denied some of the rights to Jehovah's Witnesses. And within a period of 3 years, the judgment of the Supreme Court of United States was overturned by another bench of the judgment of the same Supreme Court. So one of the judges of the earlier case was sitting at the subsequent bench and saying, I was wrong in my earlier decision. I've been hoping, and it is said, again by one of the American judges, a dissent in the court of last resort is an appeal to the intelligence of a future day, to the brooding spirit of law. I am keeping my hope on the intelligence of a future day. That future day has not arrived so far. but I live under that hope. Someday the brooding spirit of law will awaken in Pakistan also. Then, taking you to the 1974 amendment of the Constitution, which I seriously challenge, which I do not treat to be a valid piece of law. I do not treat the second amendment of the Constitution as a valid piece of law. And for that, since I'm sitting in Harvard, I will rely on some American authorities and American cases. So that and I say that the 1974 constitutional amendment was a usurpation of constituent authority. It was a usurpation of constitutional authority. And before I dilate upon that subject, I will take a few minutes trying to show you how it is usurpation of the constitutional function. Let me read something from James Madison and some of the other American thinkers. James Madison said, we maintain, it's a long quotation, I only read the last 2 lines. We maintain, therefore, that in matters of religion, no man's right is abridged by the Constitution or civil society, and that religion is wholly exempt from its Constitution. I hold that the Pakistan Assembly did not have that jurisdiction. When the head of the Ahmadiyya community appeared before the Pakistan National Assembly, he raised a preliminary objection. This assembly does not have jurisdiction to decide my faith. That objection has not been met by the Pakistan's constitution. No constitutional lawyer in Pakistan has yet answered that question, that the Pakistan Assembly or any assembly in the world for that matter has no jurisdiction to decide on matters of faith. Constitution is, if you talk in terms of the political science of Hobbes and Locke and Rousseau, Constitution is a social contract. The very existence of a state is a result of a social contract. In the modern terminology, when we frame a constitution, more particularly a federal constitution, when 3 or 4 or 5 provinces come together to frame a constitution, they enter into a contract. That basic contract cannot be altered unilaterally. And I think it was James Madison again who said that when we enter into a contract in our day-to-day dealings, but that contract is always subject to the general law of the land. Similarly, when we enter into a contract to form a state or a constitution, that constitution is with a reservation to my relationship with my Lord in the heaven. He is the ultimate governor, ultimate sovereign of the universe. So my contract with the state, or any contract with the state, with any country, so also in the United States. Therefore, the state cannot call into question my faith, because the contract is subject to that reservation that my relationship to the ultimate sovereign is the supreme, and under that I enter into this contract which is known as constitution. But there are constitutional reasons also. This is a wider political science reason that I said the constitution is a contract which cannot be violated, particularly. Now, those, when I say we do it with a reservation, is it only a hypothetical political question that I'm raising? No. It is a question which has been incorporated in the constitutional document. And that document, in your terminology, is known as Bill of Rights. In my terminology, it is known as the fundamental rights guaranteed by the Constitution, from Article 8 to Article 27, 25 or 27 perhaps. And I have this constitution, but I know my time is very short. I have to go cover a larger area. You can read, I'm referring to Article 8 and Article 20. Article 8 of my constitution, Pakistan Constitution, anybody is free to see it, welcome to see it here. Article 8 says, no law shall be made to abridge or take away the fundamental right. They could not even abridge my right, not to take away my right to identify myself as a Muslim or to express my faith as a Muslim. This is what is known, I have read somewhere in American cases, this is what is known as the tyranny of the legislature. that tyranny of the legislature persists in Pakistan. And I speak in Harvard not because it's only academic exercise and I'm trying to just gloat upon that exercise, because I think that in this world of today, which is a global world, a small world now, and we interact, and there are international human rights laws, there are international treaties, there are international relations. How can a country on its own deny certain fundamental rights and rest of the world remain silent? In the United States, the cases of Jehovah's Witnesses was overturned in a matter of 3 years because the Civil Liberties Union in America was very active. In my country, for 40 years, it has not been overturned because the civil society in my country is dumb. But is the civil society in America also dumb? Injustice anywhere is injustice for everybody. In any corner of the world, if there is injustice, this great country owes it to the world to raise its voice. I know at the diplomatic level voices are raised, but raising a diplomatic voice which is couched in many sweet political words, diplomatic words, is different from the whole civil society raising that voice, because it is the voice of your conscience. Your conscience, your constitution will say the same as I am saying. How can you enter and encroach upon the deep recesses of my inner mind and say what my faith is or what my faith is not? This is again a detailed. Then I will like to read, because the theory that I am presenting before you here is that the Constitution could not have been amended to take away that right. Because my initial Constitution did not say that I am a non-Muslim. That context stands. This is only an amendment. That amendment could not have been passed. And I refer to Justice Samuel Chase. Justice Samuel Chase says, I cannot subscribe to the omnipotence of the state legislature. The purpose for which men enter into civil society will determine the nature and terms of the social compact. An act of legislature, and within parentheses, an act of legislature, for I cannot call it a law. This is Samuel Chase. Act of legislature, he does not call it a law. The act of legislature I do not accept as law because it violates the initial contract, which I cannot, for I cannot call it a law, contrary to the first great principles of the social contract, cannot be considered a rightful exercise of the legislative authority. My parliament has exercised that right despite my challenge, despite the objection raised by me, and has not even justified how my objection was wrong. So therefore, that constitutes. I am saying all this because when a topic was given to me, it was Ahmadi Apartheid and with reference to Zahiruddin case. How can I refer to Zahiruddin case without referring to the second constitutional amendment? Zahiruddin case is rooted in the second constitutional amendment. So we have to consider the second constitutional amendment. But while we were arguing Zahiruddin case, we did not go into that question because we found that the society in Pakistan or the Supreme Court in Pakistan was too weak to take that challenge. We took another step. The step was leaving that, notwithstanding the constitutional amendment. The Ordinance 20, which was a martial law ordinance, is violative of the Article 20 of the Constitution, which has not been amended. Despite the constitutional amendment, Article 20 of the Constitution, which says everyone shall have a right to freely profess, practice his religion, that right has not been taken away. So my challenge was this Ordinance 20 of Ziaul Haq is in violation of Ordinance 20 of the Article 20 of the Constitution, and as Amjad has told you that my appeals were turned down. But again, the judgment in Zahiruddin case is a split judgment. It was a divided opinion. The leading judge, the senior most judge, Mujeeb-ur-Rahman, granted me relief in many of the issues that I had raised. The majority judgment, what is a majority judgment? He has given some example. In my country and elsewhere also, I have seen that judgment being mentioned as a Coca-Cola judgment. Because the judge says, If Coca-Cola company, in order to protect his monetary interests of a few pennies, can have that right preserved, why cannot have my religious right protected under that law? As if religion was a matter of sale, as if religion was a merchandise. They degraded religion to a level where they made it a saleable commodity. My faith is not a saleable commodity. There is no financial or economic interest attached with the faith. It is the deepest thought and my relation with my Lord which is involved. So how can we come? But that again, but you see, such silly things are not confined to Pakistan. I was reading a case of Canada, where some Scientology church or something, some church wanted to monopolize some of the expressions of the church, and the Canadian Supreme Court overturned, refused that. It's no monopoly. So that fact has been considered by the American and the Canadian courts before the decision of the Sayyidudin case. And those cases were known to the Supreme Court judges of Pakistan. And yet, in any case, I was talking of this constitutional amendment. Now, having said that, let me take you now to Pakistan. What happened in Pakistan? I'll have to be very quick because I have the, what did you say? The balance of time. So you see, Pakistan was envisioned as a secular state. Modern democracy based on Islamic principle, if you like, but a democracy nevertheless. Pakistani founding fathers did not visualize a theocratic state or a religious state or an Islamic state of that particular conception within inverted commas. They did not visualize that. It was clear before the creation of Pakistan by the statements of Muhammad Ali Jinnah, and it had been made clear by Allama Muhammad Iqbal way back in 1930s that non-Muslim need not fear because Pakistan is not going to be a theocratic state. And those who opposed Pakistan, Jamaat Islami opposed the concept of Pakistan tooth and nail on the ideological ground that we do not believe in nation state. Islam is not confined to geographical borders. It is not a nation state. We believe in pan-Islamism. So they opposed the creation of Pakistan on that principle, howsoever wrong it may be, but that was his idea. But after Pakistan, they came to Pakistan. So Maulana Maududi at that time said, the founder of Jammu, at that time said, we do not accept Pakistan because Pakistan is not going to be an Islamic state. It's going to be a secular democratic state. How can I accept that state? And when they came to Pakistan, they said, now that the Pakistan has come into being, we must make it an Islamic state. So that effort started. Let me again quickly go through this. In 1949, there was an objective resolution, which is the preamble of this constitution. And later on, by a martial law edict, it was made an operative part of the constitution as Article 2A. What is the effect of that? Again, that is a legal question. I could have talked on that quite a bit in this gathering of academics, but again, shortage of time. The question is that our preamble was couched in the language of high ideals, not couched in legal language. Constitution is a legal document. But that, even in that preamble, it said that the fundamental rights will be guaranteed and the minorities will have freedom, etc., etc. But that 1949 objective resolution today, after, for some years ago, it is being considered the first departure from the secular concept of Pakistan. And over the period of time, Pakistan has drifted down the slope and has become more and more and more an Islamic state or a fundamentalist state. And gradually, after all, now it is almost a terrorist state, unfortunate as it is. But that objective resolution was the first step. The founding fathers, they were all alive at that time except for Jinnah. They subscribed to the objective resolution because they thought that it was a hybrid kind of a thing where we will follow Islamic principles, but we will follow democracy, and we will follow the modern democratic principles, and we will follow the Islamic ideals also. So that was a hybrid kind of idea which they had in their mind. The clerics thought they have gained an inch of ground and they will now push forward. The modernists thought that they have lost an inch over a period of time, but nevertheless it continued. And based on that, there's a long history. One landmark which I want to mention is the 1953 anti-Ahmadi agitation, riots against Ahmadis. For political reasons, again, I am not saying it from my own. There were riots in Punjab. Martial law had to be imposed in Lahore because there was a demand that Ahmadis should be declared non-Muslim, and Sir Zafrullah Khan, the name is not unknown to you, he should be removed from his office as a foreign minister, and that all Ahmadis should be removed from all key posts. What a key post is, nobody defines. Remove them from key posts. A friend of mine said, the janitor who comes in the morning and has the key to open the door, he is holding a key post. So key posts so those demands were raised. And there was riot, arson and loot and burning. So in order to quell that disturbances, martial law was imposed. And then the inquiries, the disturbances were put to inquiry. And the court held that it was actually a fight between the provincial government and the central government. There again, there were constitutional issues involved. If I go into that, it will take a long time. But briefly, East Pakistan and West Pakistan, two wings of Pakistan, were at that time arguing a question, how do you maintain the balance? East Pakistan has the majority of the population, majority of the number of people in East Pakistan, and the larger area in West Pakistan. In fact, in West Pakistan you had four provinces. In East Pakistan you had one province. Population 54% in East Pakistan, 46% here. So how do you make a balance in the assembly? So they were working out, ultimately they worked out on what is known as the parity principle, parity formula. Parity formula was a first defeat of democratic principles. The people of East Pakistan had a right to be the majority, to have the majority in the assembly, but that was denied to them. So on that account, Nazimuddin, the Prime Minister of Pakistan, who belonged to East Pakistan, and Mumtaz Dawlatana, who was the Chief Minister of Punjab, there was a tussle on that principle also, and this is a long. Munir Inquiry Report is a document which should be prescribed as a syllabus in all schools of political science. I believe that, and some people believe that, and I understand in Turkey or some other countries it was prescribed as a syllabus. There they explored what an Islamic state is. But then the issue was, it ended there. In that Munir Inquiry Report, the clerics and the ulama of all the various schools of thought were asked a pointed question, how do you define a Muslim? Who is a Muslim? And they could not agree on a definition. And the court said, they all accuse each other of not being Muslim, and they have different definitions. And if we accept one of the definitions, we will be Muslim according to this definition, but non-Muslim according to all others. But if we give attempt another definition, we say this is what in the political context a Muslim means, then we will be non-Muslims in the eyes of all the clerics. So that issue stopped there, and the question of defining a Muslim or non-Muslim was not resolved. Time passed. In 1974, in 1970, Pakistan broke. Zulfikar Ali Bhutto became the first martial law administrator of the remaining Pakistan. Then that civilian martial law administrator gradually converted it to a democracy, and he framed the constitution. In that first constitution, which we still pride in Pakistan as the unanimous constitution of Pakistan, though it has been altered drastically. But that constitution did not define a Muslim. I was a Muslim like any other. And shortly thereafter, and this is my theory on that, if you want, I will give you another talk, as a result of international conspiracy, a students' clash was engineered at Rabwa railway station, which is the headquarters of the Ahmadiyya community. That engineered riot or clash was blown up, and then Zulfikar Ali Bhutto said, I am going to decide this issue in the assembly and declare them non-Muslims. Now, incidentally, without going into details of that conspiracy, that is now being admitted. Dr. Mubashir Hassan, one of the members of his Bhutto's cabinet, has also admitted that there were some foreign influences and Saudi influence and other influences were there. So, I mean, let's not go into that. But let me give you one example. East Pakistan, the breakaway part of Pakistan, which had yet to be admitted in the United Nations, the king of Saudi Arabia, King Faisal, he said, well, it's very bad that Pakistan has broken up, but after all, you are also our Muslim brethren and you are a small nation, and I want to help you out in a big way. But you know, your constitution says it will be a secular state. East Pakistan constitution was drafted within a matter of months by Dr. Kamal Hussain. And this fact has been recorded by Dr. Kamal Hussain in his book recently. So, and then this was conveyed to Mujeeb-ur-Rahman. Mujeeb-ur-Rahman said, yeah, you are our brother, you are the guardian of the holy places, and you are very dear to us, and we will welcome your help. But if your help is at the cost of my secular constitution, sorry, it is the constitution of my people, I cannot say. Right on his face, he said, that small country, small breakaway part which had not earned recognition in the United States, had the courage to say no to King Faisal, and that same King Faisal led Mr. Bhutto by different methods, which is now coming to light more and more, to amend the constitution and declare Ahmadis non-Muslim. Why was King Saud so much interested in declaring Ahmadis non-Muslim? What did he gain? That is the question which will loom large in the minds of people. That also came to light when the amendment was being debated. The question was being debated in the National Assembly. The question referred to the Assembly was, what is the status of a person who does not believe in the finality of the prophethood of Muhammad, peace be upon him? Simple question. Ahmadis do not believe in the finality, so are they Muslims or are they not Muslims? That was the question referred. That question took a back seat during the entire proceedings. But the very first, after having the biodata of the head of the community, Hazrat Mirza Nasir Ahmad, who was our third Khalifa, after getting his biodata, where were you educated, what is your education, what were you doing in Oxford, what were you doing in the college as a principal, etc., 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 then the first question which he asked, is Khalifa the head of the state? Because in Ahmadis we call our head of the state as Khalifatul Masih. So the question was, is Khalifa the head of the state? What was the relevance of that question? I have written a small book. Unfortunately, it is still in Urdu. The English version will come out very soon. So I have an idea that he was trying to pursue the agenda, fundamentalist agenda of what you see today in Iraq. That caliphate of some kind, somebody dreaming to be the caliph of the entire Muslim world and trying to win over the entire Muslim Ummah for that. But again, we leave that apart. I'm coming to Ordinance 20. I'm not forgetting, but I have already run out my time. Have I?
I think we're good. We have a few more minutes.
Can I continue? All right. So after that amendment, we became non-Muslim. So we took it in a stride. We say, all right, for the purposes of constitution and law, I'm a non-Muslim. So what? I lose some of my political rights. But I continue to be what I am with my faith. If I am reckoned as a Muslim with the Lord in heaven, so constitution let them deny me so. So we did not challenge that in the court for whatever reason. But the clerics did not sit quiet. They said, we have declared them non-Muslim, and yet they parade about this. They pray as they did, they fast as they did, and they read Quran as they did. What is this? So there was a spate of litigation in the province of Punjab, and I had the honor to argue that case, where cases were filed that the Ahmadi mosque should be demolished. They should be restrained from building minarets in their mosque. They should be restrained from building dome on their mosque. They should be restrained from calling durood on the Prophet sallallahu alaihi wasallam. They should be restrained from calling azan, the call for the prayer. They should be restrained from doing that. They should be restrained from doing prostrations and namaz and all that. So every part of religious practice was called into question. So there were many cases. 35 cases were brought in Lahore High Court. And the case was decided at Abdur Rahman Mubashir Ahmad. This Hasan Ahmad would know that case, and he has studied many other cases, but he has his own sociological angle, of which I am not going to talk today. I am only talking of the legal angle. So in that case, we argued the case, and we had a compelling argument that it is violative of fundamental rights. But the council on the other side said, yes, our constitution is law, it is right, but Islamic law is also some kind of a law. And in Pakistan, we are going to enforce Islamic law. So under the Islamic law, the mosques belonging to Ahmadiyya community need to be erased. And he tried to rely on some historical event of Masjid-e-Zarar having been demolished during the lifetime of the Holy Prophet ﷺ and certain Quranic verses. So I was called in to argue the religious side of that. I argued it for about 14 days, I think. And that was a masterpiece judgment by Justice Aftab Hussain and Samdani. They said Ahmadis are non-Muslim under the constitution, but they are non-Muslim of the special kind because they believe in Quran, they believe in Hadith, they believe in Namaz, and all their practices are those of Hanafi Muslims, so we cannot stop them. They are doing it for the last 100 years. And these particular practices which have been now banned under Ordinance 20 of Ziaul Haq, each one of them was protected and sanctified for Ahmadis, and the judge used this word. They said it has been argued before us that azan and namaz and these things are sha'air of Islam. Sha'air means the symbols, are symbols of Islam. And the judge said they are as much the symbols of Ahmadiyya faith. And it will be against fundamental rights to deny them that. So that judgment ran into about 120 pages. The clerics dare not take that case to the Supreme Court because it was a compelling case. So for a while there was again some peace. They waited and they got an ally in martial law administrator Ziaul Haq. And Ziaul Haq, to start with, when he came, I remember that phrase, I can hear it in my ears even now. On the first television broadcast, he said, "Apna aqeeda mat chodo, dusre ka aqeeda mat chedo." Don't give up your faith and don't touch other man's faith. So very neutral. And within a matter of 2 years, when he was gasping for legitimacy of his political rule, he brought this Ordinance 20. And this Ordinance 20, the second section of the Ordinance 20 says, notwithstanding any judgment of the court or any other law for the time being in force, this ordinance shall have effect. So this ordinance was meant to destroy what I had gained by the judgment of a court. So mullahs, the clerics, had a victory in assembly, declared me not Muslim. They declared me not Muslim, but they could not make me a non-Muslim. I call it a legal fiction. Some people have called it a paradox of identity. But I call it a legal fiction. And as lawyers, I ask you, how far can you take a legal fiction? Legal fiction is man is a woman, woman is a man. Therefore, can I expect a man to deliver a baby? This thing has been referred in a different way in a Supreme Court of South Africa by a Jewish judge. What is that? How far can you take that? So that is again an interest. I have studied all these cases. So in any case, then this was, they failed to make me a non-Muslim. They wanted to make me a non-Muslim through a court of law. Through a parliament, they declared me a non-Muslim, could not make me a non-Muslim because the amendment does not stop me from praying or calling myself as a Muslim. They went to a court and they failed in court, failed in the parliament, failed in the court, then they came through martial law administrator. So the martial law said, all right, so you will not do this because you pose as a Muslim. Now the posing of a Muslim, how do you pose to be a Muslim? What are the visible, this is discussed in the Zahiruddin case, and the minority view is very clear on that, so I'm not going into that. So then Zahiruddin case came up. And after that Zahiruddin case, and here I will conclude, there were a series of comments on that. And if I were to summarize that, the first comment was, I think, by Justice retired Durab Patel of the Pakistan Supreme Court. He said the judgment was flawed because it was against the Pakistan Supreme Court's own case law. It had not considered the earlier case of Jamindranath Kishore. That was a judgment by 5 judges. This is a judgment by 5 judges. These 5 judges could not overrule the earlier judgment of 5 judges. But that judgment was cited in the court. I cited that judgment. Justice Fakhruddin Ibrahim, who was our lead counsel, he cited that judgment of Jabendranath Kishore. And that judgment was not even discussed. The judges could say, we do not agree with that, we disagree with that judgment. That judgment needs to be overturned, that judgment needs to be revisited. They do not even mention that. So Dura Patel says the judgment is bad because it has ignored its earlier ruling. The judgment was also bad on account of other case decided by the Supreme Court by 5 judges, which is known as Hakim Khan's case. In Hakim Khan's case, one of the judges was also a judge sitting in Zahiruddin case. In Hakim Khan's case, he said that the Islamic law does not prevail over the constitution, and in Zahiruddin case, the Islamic law prevails over the constitution. So where do we count his opinion? He signed the majority opinion. So there was a Supreme Court lawyer in Pakistan, Mr. A.G. Chaudhary, he said the opinion, the ratio or the nature of the division is not clear. On this particular issue, 2 judges saying that the Islamic provisions prevail, 2 judges saying the Islamic provisions will not prevail, 1 judge who was in the earlier case, so the division was 2 and 2, it's not a majority. So in any case, so then there was a comment by Karen Parker, a human rights activist of San Francisco. She said it's a virtual diatribe against the Ahmadiyya belief. Then there was a comment in the SOAS, Martin Law. He criticized the judgment and pointed out the legal flaws in that. Then there was a comment by me, it was a short book, which was a critique and the comment on the Supreme Court judgment. The book was known as Error at the Apex. Then, after a number of years, no more legal comments on the judgment. Now we are confronted with sociological, anthropological comments on the judgment. I still need to examine them. I will not discuss them here, even if I have a view on this. I will not discuss it here. Now, the anthropological and social judgments, they try to say that there is something that appropriation of Muslimness has been guaranteed by this. And for that they say there is something known as foreignness within. Now these concepts are being discussed, I know, in South Asia, in many of the sociological studies. Foreignness within. If there is a foreignness within your body, you need to throw it out. So Ahmadis are a foreign element within the body Muslim polity. You need to throw it out. So therefore, they were thrown out. Now you have to examine the validity of that argument. Then there was another argument, that this judgment, which all lawyers say was seriously flawed, this judgment was in the best of liberal traditions of Anglo-Saxon law. How? Because Ahmadis have a conflict of identity. Their ontic identity is different from their legal identity. And the legal identity, because it is different, and I may not have followed the argument thoroughly, but this is in a nutshell what I have followed. I stand to be corrected if I'm wrong. So because when the case comes to the court has to negotiate and has to give effect to the legal identity, not the ontic identity. Now, ontic identity is my real identity. The legal identity has been enforced on me. It has been planted on me. I have been tagged with that legal identity. And when I challenge that legal identity, you beg the question, you say, well, your legal identity and your ontic identity is different. So therefore, the judgment is right. So I am examining that question still. So these are the few legal questions which I wanted to place before you, and I'll be happy to take any questions if you have. Thank you very much. I don't think I can keep on talking any more.
I think we'll take questions now. We have time, and there's a microphone being passed, so if anyone would like to ask questions of Mr. Rahman, please do so.
Yes.
Yeah, I'm Rajagopal. I teach at MIT and direct the human rights program there. So, so given all the very enormous obstacles that you have laid out for the Ahmadiyyas, what do you see as the next strategy? What's the path forward in terms of, options for changing the system or rules both within the country, and also in terms of, I was wondering, as part of the strategy of response, whether you can speculate about the relationship between Ahmadiyya community struggles for justice and other communities that might be facing similar sorts of issues, whether there have been alliances, there are mutual interests, those sorts of things, whether it's part of a broader constitutional, rebuilding moment in some way.
Yeah, I think it is. In Pakistan, the Christian community, they are an organized community. They have some organizations. The Ahmadi community, Ahmadiyya, the Pakistan Human Rights Commission, they are a secular voice. And there are certain other voices, they keep on raising the voice. For instance, this Sari Rahman, she proposed a bill in the assembly to amend some of the laws, and then the bill had to be taken away on account of the pressure outside, the heat building up outside. She only proposed certain amendments in the blasphemy law, some procedural amendments. She said, leave the law where it is, but at least make it more reasonable so that everybody does not go into the court or before the police station. So even that amendment could not be pursued. Then as a part of this strategy, which was being very effectively pursued by Ahmadiyya community, I know of the effort made by Ahmadiyya community, but I also know that the Christian community had also been making, at some points we also coordinated with one another. As a result of that, enough pressure was built by America and the European Union, as a result of which Benazir Bhutto and Nawaz Sharif both had been talking of amending the laws. But after all that pressure, Pervez Musharraf did in fact amend that law, only a part of it. He first wanted to amend the blasphemy law. There he did not succeed because he was also having some kind of a coalition with the fundamentalist Muslim clergy political parties. But he did amend part of the electoral process. Because the biggest harm, talking in political terms, is that I have been disenfranchised. I have no right of vote. I cannot vote as an Ahmadi Muslim. And in Pakistan constitutions, to start with, we did not have separate Muslim and non-Muslim lists. There was one list. Citizenship is indivisible. Muslim, non-Muslim, they are all citizens. And the voting right is a citizenship right. So Pervez Musharraf passed what is known as Executive Order 7 of 2007. In that Executive Order 2007, he said there will be, henceforth, there will be no separate list, there will be joint electoral list. So we had some sigh of relief after all. You see, why is election important? Because if the minority community and the majority community do not interact, it works against the solidarity of the nation. It disintegrates. When the minority and the majority community interact, then it helps integration of the society and the nation at large. So it was a welcome move because a member who wants to fight contest election, he will go to Muslims, he will go to Christians, he will go to Ahmadis, he will go to Hindus. So there will be interaction. And then also he will feel a responsibility when in the assembly to protect the minority rights. So he passed that. But within a matter of weeks, Pervez Musharraf took that order back, and Executive Order number 15 of 2007 was passed. Now that Presidential Order 15, which was passed in 2007, the election of 2008, the election of 2013 are being conducted under the same Executive Order 2015, 15 of 2007. There was an assembly, they could have amended it, they did not. And the same law is being followed. And now there is a talk of amending the electoral procedures. And I for one, and one of my lobby, part of my lobby is here. I want the international voice raised. I want the human conscience around the world. So, but we will keep on, we lobby and we work with many political actors also to see that if the procedures are being amended, maybe something can be done now. Because now the the kind of, I don't know how to describe it, and I don't know how you feel about it. We are having a very strange kind of a drama outside the Pakistan National Assembly. One Tyrul Qadri from Canada and one Imran Khan from a cricketer from Pakistan, and a man with great credibility, it seems. They are sitting down there, and they all want electoral reforms. So let's hope that these people see some reason, and when the electoral reforms come. So Mr. Gupta, is that name you said? Rajgopal. So Mr. Rajgopal, we do interact and we do hope. But as far as I am concerned, I live on the hope. As for the Ahmadiyya communities, in their 100 years history, they have not adopted violence. They will not adopt violent means. They will not go on the street demonstration. Their fight is legal battle. Their fight is battle in the minds and hearts of the people, and minds of the hearts of the people, not only in Pakistan, but across the globe. That is our strategy. Yes. I'm happy to see you, Veena Sarwa. She is one of the voice of sanity that we hear very often.
Thank you. Thank you so much, and I'm honored to meet you and to hear you speak. You gave a fantastic talk, and there's just so much in there. I wish we could have had like a couple of hours here. Two specific cases I want to ask you about. One case is about, do you know that lecturer, the English lecturer, Junaid, I think his name is, who was a Fulbright scholar, and he was at Bahauddin Zakaria University in Multan, and the Jamaat-e-Islami concocted a case against him, for which our friend Rashid Rahman was killed. The lawyer who took up that case was killed. I want to ask what's happening with that case, if anything. And secondly, I want to ask you that, one thing that really hurts us all as citizens of Pakistan we are Muslims, quote unquote, we are real Muslims as opposed to you fake Muslims. So when we go to get a passport, we have to, if you say it says what is your religion, if you write Muslim over there, which I cannot write, say, atheist or non-practicing, or you have to write a religion. If I write Muslim, I have to sign that declaration that declares Mirza Ghulam Ahmad to be
an imposter,
and and all of that. And I know of people who have actually crossed that out and then signed it as a symbolic gesture, but that's not. Not everybody can do that. And has that been challenged at all? That particular case?
That has been challenged at the administrative level, and there have been changes time and again. Sometimes when there is pressure from these countries, that performer is withdrawn and a new performer. But as it is, the same performer, now we are not required to sign a performer ourselves. Now the procedure is different. The signature is obtained. Now everything is online. When I apply for passport, I go to the passport office. He asks me question and fills the form. And it is on the computer. So if he asks me whether you are a Muslim or not, then I have to sign that, which he prints. He prints it out. I have to sign it if I say I'm a Muslim. If I say I'm an Ahmadi, it's very difficult for me to say I'm not a Muslim. So what I do is, I say I'm an Ahmadi. So he scores it out. If there is a person, there are two cases to my knowledge, where Ahmadis have got passports with Muslims written on there. I do not have my passport in the pocket. In my passport, there is an endorsement Ahmadi, because I have declared my faith to be Ahmadi. But there are many Ahmadis, I have seen their passports, and they are very unhappy about it. But there are obstacles, and I keep on going to passport office, and I keep on going to Nadra, because by default, everybody is not that literate. By default, looking at my name, Mujeeb-ur-Rahman, the man filling the form, it looks like a Muslim. He scores it out. And if I'm illiterate, I let it go by default. So some people get, but it is difficult for an Ahmadi to get a passport as a Muslim. An Ahmadi to get a passport as a Muslim and to sign that declaration is better than death for an Ahmadi. So he would not sign, never sign. So that is a general difficulty. And the other question that you said was about Rashid Rahman's case. Yeah. You see, the problem is, I think in one of these lectures, I think at Columbia or somewhere, I'm going to touch on the law of blasphemy. What is the law of blasphemy in Pakistan? What is its validity under law under constitution, under Islamic jurisprudence. The law of blasphemy in Islam is absolutely not based in Quran and Sunnah, absolutely un-Islamic. And I could talk for hours on that subject. And if necessary, have that discussion with Allama Tahir al-Qadri. It's not an Islamic provision, but nevertheless, the blasphemy law is there. So the gentleman was killed, and after that, it was difficult to get lawyers for prosecuting those assailants. So the issue was raised for quite some time, and thereafter, I think it is all quiet. I haven't seen anything on that. I have not heard anything on that.
I'm just wondering about the case of the young man who is in prison for blasphemy, for which you actually.
Yeah, he is you see, somebody who was going to defend him has been killed. And now I know Human Rights Commission of Pakistan is working. Somebody will defend him. Somebody will defend him. The Pakistan is not still that barren. Somebody will come to defend him.
Thank you. And I just want to thank you for your comments. They're very enlightening. A couple things. It's just sitting here as an American and as a police chief, it's kind of unconscionable that the police officers that Amjad was saying before are complicit in some of the torture and stuff and of the discriminatory practices of the Ahmadiyas over there. But do you think that the totalitarianism philosophy that's being implemented over there empowers or even plant seeds for the militancy, the militants?
Empowers militancy, you said?
Yeah.
You see, my view is that the militancy in Pakistan has increased over time because of some of the legal and statutory provisions. To start with, now if I say that, I may be talking of my own case, but I am now absolutely, dispassionately, independently saying this, that the Second Amendment declaring Ahmadis non-Muslim, it actually started a process of fragmentation of the society. It was feared at that time that after Ahmadis it will be turn of the Shias. So this bifurcation of the society and the fragmentation of the society was fractured. And the religious influence started coming in more and more and more, because it was a religious influence which brought that amendment. And the Taliban and the terrorist organizations, they have their presence within Pakistan also, among some Pakistan religious political parties. That fact cannot be denied. And Pakistan state as such does not acknowledge that terrorism as their state policy. But in Pakistan state, now I am saying it with quite a bit of reservation, and I would say it with all the possible due care and caution, that our Pakistan political government also does not have the political will to challenge that terrorist organizational attacks. Now, the absence of that political will could be for multiple reasons. Number one, they may have mental affinity with those people who are terrorists or fundamental organization, or they think that if they take an action against them, there will be a blowback, and that blowback will affect their government. So, but there is no political will. And sometime, I'm not in a position to say anything positive, but sometime we sitting outside, the ordinary citizens, we feel that there is a difference of opinion amongst our establishment and our political governments as to how to deal with fundamentalist attacks. Yes?
I don't think I need a mic, but my name is Maruf Sayed. I'm a graduate student here at Harvard. And my question is more historical. You said that Pakistan was established as on democratic principles. And later on, certain elements, certainly Jamaat-e-Islami, came to Pakistan and established its will and had various nefarious political alliances. But if you look at, and correct me if I'm wrong, but the establishment of Pakistan was a sort of a direct move away from one man, one vote, or one person, one vote. Having this electoral division where non-minorities have special seats in the parliament, is that a slippery slope that started right from the beginning and led to this situation where certainly Ahmadi Muslims are completely disenfranchised, but also was it right from the beginning a sort of a slippery slope that led to it?
That's a very important question. That's a very important question. Many people do not really give it a serious thought. The point is that the Pakistan was envisioned as a secular state or a democratic state cannot be denied. And this cannot be denied that the Pakistan constitution in the federal constitution republic, and it is in all its appearances, it's structured as a democratic constitution. But the other thing that you mentioned, that in that constitution also there were reservations for the minority seats. When Ahmadis had not been declared as minority, but there were other minorities, Muslim, Christians and Hindus and Parsis and Sikhs, they were there. So there were reserved seats for them. Now that, I think, was a part of the colonial legacy. And that also has its own wisdom according to the need of the time. Because this representation in India during the colonial period was on account of clash of economic and political interests between Muslims and non-Muslims, that in order to protect the minorities. Now this is very important. I have my thesis of its own, and I have talked about it at length also, that the reservation for minority seats is, in the ultimate analysis, a process of integration. Some minorities which have been left behind by process of history. In India, they call them untouchable, they call them Dalits, they call them lower caste. In Pakistan, we do not have low caste, but we have Christian community which has been left behind by accident of history. So in order to, and if they contest election in the general elections, because of the overwhelming majority of Muslims, no Christian would be elected, no Hindu would be elected. So they will have no voice. So in order to give them voice, so that gradually was supposed to be a phased process of integration. Ultimately, it turned out to be a process of disintegration, unfortunate as it is. But I can explain why it was that in those early years. That is how it is. काफी हो गया?
Hello, my name is Shanta Bahan. I attended here at Harvard a few years ago, and I actually am part of the Christian community in Pakistan, as is much of my family. And so I appreciated your actually addressing that issue, and I wasn't aware that the Christians and Ahmadis had actually been working together to advocate. I think if it were possible to have more of the minority communities working together, there might be a greater voice. I know traveling toward Khyber Pakhtunkhwa, I've seen some Sikh communities there as well. So there are other minorities, and I'm just wondering what work is being done to bring all of them together so that they can have a collective voice. And I say this also because Christian communities, so my family is actually from a slightly more privileged community, but Christian communities are relegated and safer in some of the areas that are, I don't want to call them slum areas, but they're areas that are not quite so nice. They tend to be safer in those areas than they are in some of the wealthier districts. So I'm just wondering, what can we do to bring a collective community of minorities together to work together to advocate for more freedom?
I think given the Pakistan circumstances, Ahmadis and Christians and other communities, they interact, they help one another, but they are not seen acting together. That is what raises your question, that they should be more visibly together. And in terms of logistics, in terms of ideas, in terms of work, they do interact and cooperate with one another. But in Pakistan society, sometimes it can be counterproductive. When some Muslims work with Christians or some Muslims work with Ahmadis, so Ahmadis can then be, or Christians can be said, oh, they are aligning with Ahmadis who are not loyal Pakistanis. And Christians are as much loyal as any. I mean, we had that squadron leader, Cecil Chowdhury in Pakistan Air Force. He had earned great honors, and we had, in the Air Force, we had Christian officers. So Christians are as much loyal as any other Muslim, and they would not like their loyalty to be clouded. So, so far as the faith is concerned, Christians and Ahmadis can interact, but for political reasons, their interaction is not visible. I can only say that. Beyond that, I don't think I can say anything. But there is complete identity of interest, complete identity of work. There is no doubt about that. I am an proactive worker. And I have met the Bishop of Lahore, and I have met Charles Amjad Ali, who was a dean in one of the Christian seminaries in Rawalpindi. I have worked with him for quite some time. Charles Amjad Ali is, I think, now somewhere in America or in England somewhere. He is not in Pakistan anymore. But Charles Amjad Ali and I and Bishop of Lahore, we have been interacting, meeting in the American embassy, in the general embassy, in the German embassy, and some other European embassies. So we have been working together.
Let me just again thank you so much for joining us today, and thank you everyone. It's great to see such a wonderful turnout.
Thank you so much again. You have done me a great honor. I am privileged to be in this Harvard Law School, one of the prestigious law schools in world, if I say, and many of the world leaders, many of the judges of the United States Supreme Court, many of the presidents maybe, they came out from this Harvard. So Harvard is a great name, and for a humble man like me to be in Harvard speaking to this galaxy of students and academia, it has been a great pleasure for me. Thank you all for giving me such a patient hearing.